John, would you please lead us?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You may be seated. I now call the scheduled meeting of the Board of Adjustments to order. Mr. Bodie, from the Planning and Development Office, please describe the function and operation of the Board of Adjustments to our applicants in the audience.
Yes, Mr. Chairman. The Board of Adjustment is a quasi-judicial body established by the Board of County Commissioners under Chapter 62, Article 2, Division 4 of the Brevard County Code. The Board of Adjustment is empowered to hear requests for variances to the zoning regulations and sign regulation in Chapter 62, Article 6, and Article 9. Pursuant to Florida Rules of Appellate Procedure, any person or persons jointly or severally aggrieved by any decision of the Board of Adjustment may, within 30 days after the date the order is signed, apply to a court of competent jurisdiction for appropriate relief. Mr. Chairman, you have 4 items on your agenda today.
Thank you, sir. Mr. McCann, would you please explain to the applicants in the audience the definition of a hardship?
An undue hardship. A variance may be granted when it will not be contrary to public interest and where, owing to special conditions, a little enforcement of the provisions of this chapter will result in unnecessary and undue hardship. The term undue hardship has a specific legal definition in this context and essentially means that without the requested variance, the applicant will have no reasonable use of the subject property under existing development regulations. Personal medical reasons shall not be considered as grounds for establishing undue hardship, sufficient to qualify an applicant for a variance. Economic reasons may be considered only in instances where the landowner cannot yield a reasonable use and/or reasonable return under the existing land development regulations. The applicant must answer a variance hardship worksheet with 6 questions. The Board of Adjustments will discuss these questions today with each applicant who has requested a variance.
Thank you, sir. I'd like to address the board members, the applicants, and our audience for a moment. The Board of Adjustments, as a quasi-judicial board with members appointed by the Brevard County Board of Commissioners, will utilize Robert's rules to conduct our meetings. The chair is asking all board members not to ask questions while the applicants are making their presentations. Once the applicants have completed their presentations, we will begin board questioning with the board member who represents the applicant's district. When concluded, questioning is open to the full board. The chair will recognize each board member wishing to speak. Once all board members have completed their questioning, we will then open it to the audience who may be here to speak concerning the applicant's application. Anyone from the audience wishing to speak will be given the opportunity to address this board, but only once. At the conclusion of public comment, the applicant will be given additional time for rebuttal, as well as to present their final comments. Once completed, no further comment will be heard from the applicant or the public. We will not use a timer for this meeting. Instead, we will ask each speaker to be concise in what they have to say. It is important that you stay on subject and avoid information that is not relevant. All persons speaking must provide their name and address for the public record. Those wishing not to verbally state their address may ask the clerk at the podium for an address card. Please fill it out and return it to the clerk. Are there any questions from the board members about the chair procedures? Are there any questions from the applicants about chair procedures? Are there any questions from the audience about chair procedures? Seeing none, our first order of business is to approve the minutes from our previous meeting.
Mr. Chair,
Sir.
I move for approval of the minutes from the April 19th, 2023 meeting.
We have a motion from Mr. Thomas to approve the minutes from our last meeting. Do we have a second?
A second.
We have a second by Ms. Mallard. All in favor, aye.
Aye.
Any opposed, no. And our minutes are approved. Mr. Bodie, may we please have the first applicant that is requesting a variance?
Yes, Mr. Chairman. Item number 1, Trevor T. Hallman requests variance to Chapter 62, Article 6, Brevard County Code, Section 62-1341-5A to permit a variance of 2.15 feet from the required 7.5-foot side west setback for a principal structure in an RU-1-9 single-family residential zoning classification. And this is located at tax account number 2727893 in District 5.
Would the applicant please come to the podium?
Hello.
Hello, sir. Please state your name and address for the record.
My name is Trevor Heyman, and the address is 340 Avenida Del Mar, Indian Atlantic, Florida, 32903.
Please raise your right hand. Do you swear or affirm that the evidence you're about to give this Board of Adjustments is the truth?
Yes.
How may we help you today?
Okay, so I'm applying for the variance for a addition.
I'm sorry. Yeah, as close to the mic. as
Okay,
you
yeah, I'm applying for a variance for an addition for a mother, well, not really a mother-in-law suite, an addition for my parents that moved back in. The only issue was that I didn't have the clearance between the property line and the new addition. I have a survey here if you guys want to see that. I also have the drawings for the addition.
Okay. Hang on just a second. The variance is for an addition you're wanting to build?
Yes. That's correct.
I'm confused. That's not what I'm looking at.
The variance is to legitimize the existing house and for the variance for the
that is
proposed
correct.
addition. The existing house does not meet the 7.5-foot side setback. The carport was enclosed into a garage, and it is now at 5.35 feet, so it was to legitimize that whole side setback on the west property line.
But we're not technically dealing with the addition.
No,
that
the
he's
addition
building.
does not meet the 7.5-foot setback either, excuse me. That's the reason it was put on the survey as a proposed two-story CBS addition, and he's matching the back, so it'd go down the side.
Yeah.
Do you have the survey, the latest survey
We
that shows
do,
it?
sir.
Okay.
But I guess in our description, it says the only thing that we're doing is legitimizing the existing structure.
No, so Mr. Hammond is with, if the Board of Adjustment approves this variance, it would also allow for the addition
Okay.
to meet that proposed setback, which you would have to grant, because without it, it still is in violation of the side setback.
Okay, sir. I
Yes,
just
sir.
wanted to make sure we weren't doing just half of this and not covering both,
Correct.
so.
Yes, it'd be as proposed on the, it shows it on the survey, so it'd be as proposed on the survey with the addition.
Okay. Thank you, gentlemen. Appreciate it very, very much. And you are in District 2, I believe, or District 5, I'm sorry. So, Mr. Newman.
So, all right, and I'm kind of following along with that as well. So with this addition that you're having here, this is separate from the carport that was also there, correct?
Correct.
Okay, got it. And then your, I know that it's two-story and that it has there's at least one additional one in the neighborhood or something similar to this?
Oh, yeah.
Have you
There's
seen?
a couple of two-story houses that have been additionized, yes.
Okay, got it. Let's see, just taking a look here, don't mind me while I'm just kind of wrapping our head around it. Let's see. So would this be two separate issues then, that we're trying to split out and that would be one?
That's what I was
Yeah,
asking.
that's
No,
right.
it is all one.
Okay,
So
At the mo-
when we approve the setback, and
And
please
that
correct
is
me if I'm
approved,
wrong,
yeah.
when we approve the setback, we're approving the setback for the
And-
existing structure and for the new construction that is being built.
Yeah, so if you approve the variance, it would apply to the structure along that property line, whether it's existing or proposed, that will have to meet that setback.
okay, because I don't have any questions about the carport or the portion that I kind of read out in here, that seems like straightforward in that regard, if I'm going to go backwards to go forwards. You had bought this property, it was already built there, you need a variance for that, that's settled for me. And if that's where we're going, I really, if that encompasses the whole, I don't necessarily have any further questions. So I could open it up to you guys.
Good.
Yeah.
Any questions from the other members of the board?
No question. I do.
Yes, sir.
The addition that you're going to build to the rear of the residence, the area between the addition and the property line would be greater than what's existing between the residence and the property line right now.
It will be, would it be greater?
Yes.
It would be, well, it would be the same as it is on the survey. I would be sticking to the existing line of the house to where the addition is on the same line as the existing carport.
I see a 6-foot distance between the
Correct.
current house and the property line, and then at the rear of that structure, it's going to be, looks like 6 foot,
6 foot
6.6 foot.
That's correct, because the property line goes at an angle.
Okay, thank you.
Are there any other questions? Sir, if you please just stand to the side for a moment. Is there anyone here that would like to speak in favor or opposition to this variance request? Seeing none, please come back. Any final comments that you have before we move forward?
Nope.
All right. Thank you very much.
Thank you.
What is your pleasure, gentlemen, ladies?
I'll make a motion to approve the variance as depicted on the survey.
We have a motion by Mr. Newman to approve the variance as depicted on survey. Do we have a second?
A second.
We have a second by Ms. Mallard. Any discussion? Let me read through the 6 points. Special conditions and circumstances exist which are not applicable to other land, structures, or buildings, the applicable zoning classification. The only special conditions that are there is that this structure was in existence previously, and so we are approving the variance that would bring that structure into code by granting this variance. That special conditions and circumstances do not result from the actions of the applicant. Again, the structure was already in existence, and any future structure that he would build would have to meet within those guidelines. So this is not something that he built and therefore would not be something that he created. Granting of the variance requested will not confer on the applicant any special privilege as denied by the provisions of this chapter of other lands, buildings, or structures in the identical zoning classification. He is not being given any special privilege. It is something quite common when somebody is wanting to build that they come before us, and a structure was built long before a code was put into place and had to be legitimized. So we're not conferring on him any special privileges. That literal enforcement of the provision of this chapter would deprive the applicant of rights commonly enjoyed by properties in the identical zoning classification, and the provisions of this chapter will constitute an unnecessary and undue hardship on the applicant. It would certainly create, in my opinion, an undue hardship, as he would literally have to remove portions of the house in order to come into compliance with code if we do not grant the variance. That the variance granted is minimum variance that will make possible the reasonable use of land, building, or structure. And I believe that we have already stated the reasons for that. And that granting the variance will be in harmony with the general intent and purpose of this chapter, and such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. Again, the structure has been there for many years. So I believe that it would be in harmony with the intent and purpose of the codes that are in place. Any other discussion? If not, I'm going to call for a vote. We have a motion and a second to approve this variance. All in favor say aye. 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 Any opposed say no. Your variance passes. Thank you, sir. Yes, sir. Mr. Bodie, may we have the next applicant requesting a variance?
Yes, item number 2. Ernesto Diaz requests variance of Chapter 62, Article 6, Brevard County Code, Section 62-2118D3, to permit a variance of 3.1 feet over the 16-foot projection, 20% of the width of the waterway permitted for a boat dock in an RU-1-11 single-family residential zoning classification. This is located at tax account number 2431874 in District 2.
Would the applicant please come to the podium?
My name is Ernesto Diaz. My home address is 1690 Rochelle Parkway, Merritt Island, Florida, 32952.
Please raise your right hand. Do you swear or affirm that the evidence that you're about to give this Board of Adjustments is the truth?
I do.
Before we begin, we do have an objection letter in front of us. Have you seen that objection letter?
Yes, I did.
And you've read it over?
Yes, I did.
Okay. How may we help you?
And I brought plenty of pictures. I actually took the time yesterday to do an aerial video recording and pictures of the canal width. And part of the objection, if you read through it, you'll see that apparently I'm obstructing that person's view. And I'm also causing an obstruction during hurricane season. If you go through the pictures, I mean, I can show you here. You'll clearly see that my dock actually doesn't protrude outside. It doesn't project into the canal any further than the existing structures that are in there.
Hey,
Will you
hang on
guys-
You
just a
can't,
minute.
unless he's able to print out pictures of what that is, so we can submit
I
it part
do.
of the record.
Yeah.
You can't put that into the record.
Oh, I'm sorry, I didn't know. I figured this is gonna be good, but as you can see,
Again, I can't use that.
yeah, I didn't know. This is my first time doing something like
Okay.
this.
That's all right. I just have to stay in with,
So,
so just give me descriptions and I'm fine.
So what happened is I purchased a house last year, late January, and the house originally the original owner did a repair for the seawall, and that seawall, the repair that they did wasn't very good, and it collapsed. When I purchased the house had the backyard was fine, but within 3 months I started getting holes on the corner of that seawall, which pushed me to actually pull the permit and be able to, make a repair. Unfortunately, what I didn't know is that I wasn't able to actually build a seawall that was going to be projected into the canal further past what I wanted to do, because the ultimate goal of me doing that repair was eventually to be able to build a dock with a lift for my boat. And I did the seawall passed inspection, everything was fine. But now apparently, I am projecting further past what the code allows. What my mistake was that I actually misread the law, and I figured it was 16 feet from the existing seawall, not the property line. And since my property line was way back, because the house actually encountered 3 repairs, I had no option at that point, and the permit was never approved. It was never my intention to do anything illegal. I just didn't know, and I felt confident that I was following all the codes, and based on the existing structures on the canal, I figured it was going to be okay. And now all of a sudden, I encountered this situation where I am not.
All right. You are in District 2, which is Mr. McCann. Sir.
Good afternoon. Just to clear it up with my other board members, your house is not at the very end of a canal. You're not at the dead
it's
end. Okay. The seawall currently existing was constructed just past the previous seawall,
Correct.
so it extends a
In
little bit
front of-
further out into the canal.
Yeah.
Does that seawall extend any further out into the canal than your next door neighbors?
Yes. Well, there's one neighbor that actually is aligned with me. Apparently, in the past, he asked for a variance to get it approved because he encountered the exact same situation as me. So his seawall and mine are both aligned.
Okay, so you're aligned with the next door neighbor's seawall.
Correct. And his dock is aligned to mine too. And I think this the one person that is actually complaining or putting the complaint with the city. Because he had zero obstruction before I purchased the house, because the previous owner never built any docks, never had any docks, or nothing. And then all of a sudden I came in and I built the structure right where he had his chairs, and I had a front view to the canal. And yes, I am obstructing that now. But just like everybody else, every house in the neighborhood has a dock. I think it's only fair,
Does the next door neighbor, whose view you say you may be obstructing, do they have a outdoor kitchen built in their backyard?
Yes, they do.
And do they have a roof on their dock?
Yes, they do.
Do either one of those structures obstruct their view?
Well, I guess, yeah.
Do you know the width of the canal?
It's 80 feet. I actually double-checked it with a laser.
Okay. And the property directly across the canal from you, do they project out
Only
And
5 feet.
Only about 5 feet?
And I know the owner, he's a dear friend of mine, and he told me he has no intentions to build the dock even further. So in reality, even with my dock being extended 3 feet, I'm at the widest point. My house is the widest point of the canal.
I have no other questions.
Sir? Ma'am? Ms. Mallard, do you have any questions?
No.
Mr. Newman? I don't have any at this point. If you could, well, yeah, I do, just one. You haven't built the dock yet, or you have built it?
The dock is already built, yes,
The
sir.
dock is already
Yes.
built?
Yeah.
When you permitted the dock, it gave you what you were permitted to build?
Yes, I submitted all the drawing. I did the survey twice because I did pull the permit for the seawall before I started. Then one thing led to another, and then I submitted all the drawings since the seawall was approved with no issues, and I kind of like familiarized myself with all the code laws and how to build it. I figured, okay, I'm going to submit for permitting, and then I'm going to proceed with the build.
Okay.
That was my mistake.
And you built the dock yourself?
Me and some friends, yes.
Okay.
I'm very handy.
So, just don't measure well. Okay.
You can go. I mean,
So when you permitted the dock before you built it, correct?
yes, I submitted everything before I touch anything.
Okay.
But it was not.
And so
approved.
your error was,
I never waited for the feedback from the city. The city took, I think it was 2-3 weeks before I heard anything from them.
so you applied for the permit, but the permit had not been issued before you started building?
Correct.
Okay.
Yeah.
And,
I know. It's a mistake that I will never make again. But I've been in the construction industry myself since I was a kid. I'm a licensed plumber, and I figure, 95% of the time, we actually start the work the moment that we submit everything for permitting, because you know exactly what could go wrong and what could this. And honestly, I didn't think this was going to be a problem. I read the laws, I brought it with me. I figured it was 20% of the canal width. 80%, the canal was 80 feet. 20% of that is 16. The dock that I built is 14.6. So if you go see, you see that I stayed on the safe end. I never thought that it was from the property line. Nothing that I read online told me that. And when I received the feedback from the city, they were the ones that told me, no, it is not the seawall, it's the property line. And then at that moment, I realized that I made a huge mistake.
is why you
Unfortunately,
wait.
the boat was already hanging in there already.
okay, which is why you generally wait for your permit before
Yes.
you start building.
Yeah. Lesson learned.
But let me just tell you, I've seen projects shut down because they started building before the permit was issued. In some areas of our state, that's permitted. It's not here, and I've watched projects get shut down many, many times for extended periods because they started building without permits.
Yeah.
And so, okay. All right, thank you. If you stand to the side, please.
Sure thing.
Is there anyone here that'd like to speak in favor or opposition to this variance request? Seeing none, please come back. Any final comments?
No, sir.
From the board, any additional questions that has been raised?
Thank you.
You may have a seat.
Thank you.
What is your pleasure?
I'll make a motion to approve the variance request as depicted in the survey.
We have a
Second.
motion by Mr. McCann. We have a second by Mr. Thomas. Am I correct?
Correct.
Any discussion?
I visited the location yesterday, and I want to first address the objection. The next-door neighbor to the immediate west of this location is the party who submitted the objection. Their platform for their dock is on the opposite side of where their boat lift and their boat lift's roof is located. So they're not going to have a very good view down the canal to begin with their boat lift and roof obstructing their view. They also have a large outdoor kitchen in their backyard. I'm not criticizing it all, but I don't see how Mr. Diaz's structure that doesn't have a roof would impact their view significantly, or even at all for that matter. It is a wide canal, it's 80 feet. If you take away the 16 feet in which the neighbor could build, the neighbor across the canal could build, and you take away your 14 and a half feet, we still got 50-foot wide canal of water between the dock edges, which is quite a good distance away, and I don't think it would impact any navigable issues with any boats.
Any other discussion? I have one point I make on every single one of these, and I make the same point every time one of these comes before us. I think we have to be careful, because at some point there's going to be issues if we continue to allow people to build out beyond what code allows. I think by looking at the overhead, Mr. McCann, you're correct. I think about everybody there's already built their boat docks, so we would have probably less opportunity for issues with this situation than we do in a lot of them that we see. It does concern me that we built without a permit. That is always an issue and always something that, as you now know, you should not do. And that always does raise questions for me. When we build without a permit, then I have to decide, did he honestly make a mistake, or was he just trying to get ahead of the game so he could come back later and go, yeah, I messed up, sorry, I didn't know. One of the reasons you didn't know was because you didn't wait for proper procedure. And then now we have to decide whether we're going to allow you to keep that or whether we're going to make you correct it. And as the hardship states, I can't take whatever financial cost that would be, in the place. Yes, sir.
I'd like to say something.
Please.
He actually did have a permit for it. The permit
Okay.
was approved to go out off of his property line 16 feet, so
Okay.
he did have a permit for it.
All right.
And-
So
and then
he did have the
then-
permit?
Yeah, it wasn't approved for the 16 feet to go off of his property line.
It was the
Is the
as-built.
as-built
So it was the
survey.
as-built that
Yes.
came back?
That-
Okay,
that-
okay,
that-
okay.
The
Then in
as-built
that
threw
case,
the
I stand
wrench into
corrected.
it.
Okay.
He states he was measuring off the new
He was
seawall.
measuring off the
so
seawall
that
instead
was
of the property line.
Yes, but he did have a permit for the dock to start with, and it was approved at 16 feet off
Okay.
of his property line.
Thank you for correcting me then. In that case, then, in my opinion, it was a legitimate error. You did what you thought was correct. In this case, it wasn't. I can tell you that we've seen that happen many, many, many times where people didn't understand the difference between property line and seawall. So that makes me feel much better about this, in the fact that you weren't building without permit. You just made a legitimate error. So much of what I just said then wouldn't apply. So, all right, let me read our 6 points. Special conditions and circumstances exist which are not applicable to other land, structures, or buildings in the applicable zoning classification. I will use what is given in the applicant's response, and probably the new seawall being built 3 feet out would be the only special circumstances or conditions that would apply here. That special conditions and circumstances do not result of the actions of the applicant. They do. The new seawall's being built, and then he built the structure not from the proper line, so he did create this particular situation. The granting of the variance will not confer on the applicant any special privilege as denied by the provisions of this chapter of the lands, buildings, or structures in identical zoning classification. Again, we would not give him any special privileges. We're not going to say yes or no because we like him or don't like him, or know him or don't like him, or don't know him. So that literal enforcement of the provisions of this chapter would deprive the applicant of rights commonly enjoyed by other properties in identical zoning classification under the provisions of this chapter, and will constitute unnecessary and undue hardship on the applicant. It will not. It doesn't deprive him of the use of the waterway. It does not deprive him of rights and, that would be enjoyed by other properties if we said no. He just would have to have a smaller dock. And it wouldn't create an unnecessary or undue hardship, in my opinion. That the variance granted is the minimum variance make possible to reasonable use of land, building, or structure. It would be the reasonable or the minimum variance required for the dock which has been constructed. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, and such variance will not be injurious to the area involved or otherwise detrimental to public welfare. I'm going to defer to Mr. McCann on that one, and the fact that he is saying that, and correct me if I'm wrong, sir, there's plenty space between docks and so forth that are already constructed. If this was approved, that it would be in harmony with the area and would not be injurious to the public welfare.
Yes, in fact, it's in line with several other docks along that side of the canal.
Okay, thank you, sir. We have a motion and a second to approve. I'll call for a vote. All in favor, say aye.
Aye.
Aye. Any opposed, say no. And your variance passes. Mr. Bodie, may we have the next applicant requesting a variance?
Yes, item number 3.
I feel like you guys just lifted a ton of brick on my back.
I'm-
Truly heavy. Thank you so much.
Thank you.
All right, you guys have a good one.
Item number 3, John K. and Rebecca J. Marshall request variance of Chapter 62, Article 6, Brevard County Code as follows. Variance number 1, Section 62-1336-5B to permit a variance to allow an accessory structure to be located forward of the front building line of the principal structure. Variance number 2, Section 62-1336-5B to permit a variance of 6.29 feet from the required 15-foot side south setback for an accessory structure / carport in an RR-1 rural residential zoning classification located at tax account number 2702720 in District 5.
Would the applicant please come to the podium? And I should have said this earlier, you can start to the podium while he's reading the case if you desire. Please state your name and address for the record.
Rebecca Marshall, 1575 Harlock Road, Melbourne, Florida, 32934.
Please raise your right hand. Do you swear or affirm the evidence you're about to give us Board of Adjustments is the truth?
Yes.
And how may we help you?
Well, we built a carport too close to the property line, which we weren't aware of any of these codes. It's also forward of the house, only because there was no other place to put it. And unfortunately, I was given poor advice, and we did not have a permit for the carport.
Okay. You're in District 5, so Mr. Newman.
Heather?
Hello.
So let's start with the carport. What advice were you given about the carport?
That I didn't need a permit.
Was that like a neighbor, a contractor?
Contractor.
A contractor told you that? Okay. All right. And so now I have on here that it says that, well, you already have the violations for the carport and the shed. You're keeping the carport up as is. It says that they're taking down the shed according to a survey. It says currently removing, but
It's
you're keeping
gone.
the carport. Is that correct?
Yes.
Okay. All right. Now, on that, it states that you put it there for, that there was no other place to put it, or was that the shed?
The shed has been there for 20, 30 years, so it's just gone.
Oh, no, but the carport.
The carport.
There was a note in here about the location of the carport because of septic tanks, et cetera. Is that why the carport is where it is, or was that where the shed was? What?
No,
'Cause-
that's why the carport is where it is.
Okay. Got it. And then, and you're not asking for, so if you're removing this shed now, you're not asking us to approve anything for that. You'll be removing that, placing a new one elsewhere or something to that degree?
Correct.
Okay. And then how long's the carport been up for?
2019.
Okay. Let's see. And then you guys, did the person who gave you the advice, was that the person who built it for you? Or did you have a family friend, or how did that happen?
No, it was built by the contractor.
Okay. I'm good for right now.
Gentlemen? Ladies? No questions? Any questions?
Just one.
Please.
Have you had any complaints from your adjacent neighbor?
I believe one neighbor complained.
Is that how this came to pass?
Yes, sir.
Okay, thank you.
Has the shed already been removed?
Yes, sir.
Okay. And you're going to build another shed, and you're applying for permits for that, I assume?
We will, yes.
Okay. You may not know the answer to this. This is more curious. Why did the neighbor complain about your carport?
I don't know.
Okay. Does it protrude, does it protrude out to where it blocks any view of people traveling up and down the road, anything of that nature?
I don't believe so.
Okay. Mr. Newman, did you go by the property?
I did not know.
Okay.
No, I'm generally familiar with the road, though.
From the description, from what you're seeing in the overhead, do you see any issues with safety?
No,
Okay.
no, it's mostly by an empty lot to the, or not empty lot, I'm sure somebody owns that by the house there, but it's not near anybody's structure. It looks like storage or concrete. It looks like a company kind of owns it for sand or something.
Okay. Which neighbor is it that complained? Are they next to you?
Yes,
Is it the one on the side that the carport is built?
yes, sir.
Okay. All right. That's all the questions I have. Any other questions? Sir?
Just one. Is there anything, any physical barrier between the carport and your property and the neighbor's property?
We do have a fence.
So
There's a
something that-
privacy fence.
Okay. So they're not looking directly into your carport?
No.
Okay. Thank you.
If there's no other questions, if you stand to the side for a moment, please. Is there anyone here that would like to speak in favor or opposition to this variance request? Good afternoon.
Hello.
Please state your name and address for the record.
Mike Dalton, 4730 Aurora Road.
Okay. Please raise your right hand. You swear or affirm the evidence you're about to give this Board of Adjustments is the truth?
I do.
Are you in favor or opposition?
Opposition.
And how may we help you?
Very true, it is, the structure is built next door between my property, which is, I've been looking into getting permits for residents. Do you guys have pictures of this?
Yes.
Okay. If you can tell just by the fence, this is a very large structure, probably 18, maybe 20 feet. It's built very close to the property, and it's built in front of their house. So my property just to the south, the house that's going to go there will be facing Harlock Road. If you want to look at it like obstruction, this structure is in front of the, it's going to be in front of the new front line of the residence to the south.
Yeah, but her carport's probably, and I'm guessing, 30 feet back from the road?
I'm not sure, probably 30 feet, but
Okay.
that's the front of the house line is also back that far too.
Right. So this would hamper your construction or?
It's, you know, a little bit of everything. I mean, property value. I mean, in my eyes, it looks like a trailer park structure. If you take a good look at it, it's not I mean, it's very big. It looks almost industrial in front of a house. And that's what I have a problem with. I don't think you guys would grant a permit if somebody went to you and asked to build that in front of a house and 6 feet from another residence.
Okay. Did you just recently acquire that property? You've had that property for a
It's been
while?
in my family's for 30 years.
Okay. And it was never a problem until now that you're ready to start the build, or you just never noticed it for the last 4 years?
Well, there were trees, complete growth in between their property and ours, and once you've taken everything down, now it's like a sore thumb.
Well, who took the growth down? Huh?
What was that?
Who took the growth down?
I did.
Okay,
It was pepper trees.
okay. So you couldn't see it until you removed the growth that was on your property, and now it's become an issue because of that?
Correct.
All right. Does the fence help with that at all?
The very, maybe bottom 5 feet of it,
Okay.
but
But, and I don't mean this to sound curt, it's going to, I don't mean for it to, okay? If you had left the pepper trees there, it wouldn't be an issue?
correct.
Then do you mind if I ask, why didn't you just leave the trees?
Pepper trees?
Yeah,
I don't think people use pepper trees for their landscaping these days.
okay.
Sorry about that.
But
oaks
your
and palm
parcel of
trees.
land's a pretty good sized parcel here, is it not?
Correct.
Are you building on that side of the
Yes.
property?
It's going to be, it was 2 pieces, it became 1, and then it's going to become 1 or possibly 2 lots on that corner.
So you're going to divide that lot up?
yeah.
Okay. So that makes sense, and that's why you're building closer to that
Correct.
side? Okay. Because my next question was going to be, why didn't you just build further away from there? Okay.
Mr. Chair,
Sir?
have you by chance had anybody come out and estimate your property value that said, okay, without that structure there, that your value would be valued at X number of dollars higher?
No.
I didn't think so. I just thought I would
Yeah,
ask.
no.
Thank you.
Sir?
When exactly did you submit your complaint?
I don't know, it's on the paperwork a few months back,
Estimate, please.
4 months ago.
4 months ago. And when the carport was being constructed, were you aware that it was being constructed at the time?
I noticed it there, yeah,
Okay.
through the woods when I was in the back of the lot.
Are you also able to see it from the street?
From the street, yeah.
Okay. Thank you.
Sir?
So just to, and I'm kind of wrapping it all in a bow, so you may be repeating some of the stuff that you said prior. So the main complaint that I'm hearing from you is property value for the integrity of the neighborhood. Is that correct? Okay. And then I'm looking at an overhead aerial shot, just so you're aware. Basically, I'm just seeing a lot of clearing, a lot of sand. I assumed that you owned a construction company because I don't know what you do, and it was an aerial. So in this particular case, this is you, have you already built or started building these structures, or was that just the clearing that I'm looking at right now?
You're just looking at fill dirt brought in.
Okay. Okay,
And
got it.
getting rid of all the indigenous trees and stuff that's not desirable to have in a lot.
Okay, gotcha. And then I am looking at I just don't want to make an assumption, and you live there. I'm looking at a tree line based on where you stopped clearing. Is that practically what the easement is?
No, it's actually further in, but there's oaks and palms in that tree line.
Okay,
I didn't take those out.
okay, fair enough. Okay, that's all I have.
Ma'am? You have any questions? No. Okay. Sir, thank you for your time coming in. We appreciate it very much.
Thank you.
Is there anyone else that'd like to speak in favor or opposition to this variance request? Come on back. Any final comments?
Well, since we have moved in, our property value has doubled with the carport there. And it's an RV port. That's why it's so big. And, no, I guess I don't have anything else to say.
Do you park an RV in it?
We sold the RV,
Okay, so now it's just a standard carport, just extra large?
yes.
Okay.
Okay, so it's taller than normal. Is it wider than normal as well? I don't know if normal is the right terminology, but
It, I don't,
is
I
it bigger
can't.
than like a two-car garage, side by side?
Well, there's a carport side and then the RV side. So
Okay.
it's double, oops, I'm sorry. It's
Okay.
double, and then it's high enough for, you know.
For an
our
RV.
Small RV.
Okay. Other questions? Seeing none, thank you very much.
Thank you.
What is your pleasure?
All right, so for, I think there's actually a lot to unpack here, and I'd love a very good discussion about it, because I can honestly see kind of both sides of it. So if we can definitely do that, but I will start it off. I'm very sympathetic to the property value, integrity of the neighborhood discussion. So I'll start with a no, but that can be changed, but I'd at least like to start discussion and have a motion on the table. So a motion to not approve the variance.
I'll second.
We have a motion by Mr. Newman to deny the variance. We have a second by Mr. Thomas. Discussion.
Okay, so at least, so one thing that during my time on this board, Mr. Rhodes, was essentially making sure that we're not enabling people, we actually just talked about this 2 things ago, about, not enabling contractors or individuals to just build things, and apparently it was a contractor who built this and knew, they should have known if they have a license that there should be a permit in place. So that was the biggest red flag for me at the start. And then from there, I wouldn't want to approve something that's going to harm the property value of a developing neighborhood in that regard as well, especially because it was not followed by proper procedure. So that's kind of my starting point on it. Very sympathetic, by the way, of that situation. I totally understand you not knowing and not being a contractor yourself and getting bad advice. I get that, but the genesis of it causes a problem for me.
Okay. I need, this is probably out of order, but I need to ask a question. Can you come back just a minute? And Madam Attorney, if I'm out of order, you have to yell at me. Have you been in contact with the contractor since this came up?
No, sir.
Do you have intention to contact that contractor since this came up?
I don't know why.
Well, if we didn't approve it, it's going to have to be removed, and that, since he didn't get a permit, it would be,
Well,
he'd
we-
be liable.
We have a permit now. We got the permit prior to the variance, all, in conjunction. So we
Okay.
do have the permit to go with the variance.
Okay. All right, thank you. Explain. They have a permit now?
Hang on one second.
So as Paul was looking that up, so the property owner could have applied for a building permit for the structure, and we could have put it on hold because they needed 2 variances. So just because they didn't apply for a permit back in 2017 when the structure was constructed, it doesn't mean that in 2023 that they haven't applied for one.
Okay.
So they did apply for a building permit. The zoning department has it on hold. A variance will be needed to have the structure in front of the principal structure, the home. Variance application waiting, so.
Okay. Thank you, sir. Mr. Newman, continue.
Yep.
Sorry for the interruption. I just needed to know if she had made contact. To me, that's important, because if the contractor made the mistake and we're going to require her to take that down, then that would be something that She could certainly go back to the contractor on.
And from what you're hearing there, she should be able to go after him for that because they didn't do it at the proper time, because this looks like this is to fix the problem.
Correct.
Yeah, so that, I think it's on the contractor. That's what I'm kind of leaning towards right now.
Well, I concur with Mr. Newman. I think it's a shame that Ms. Marshall was put in this position, but by that same token, Mr. Dalton has the right to enjoy the maximum value of his property, and I could see, without an expert's opinion, I could see how that carport would definitely affect value, and he should be able to remove pepper trees or whatever shrubbery he has on his property without it adversely affecting, he should be able to enjoy his property however he wants to the maximum value. So with that, I just think it's injurious to the area to approve the variance.
Sir?
I always like to
See, I
add my
get to
2
go last.
cents.
Leave it to the attorney.
I'm looking at the survey that was submitted, and the carport that was constructed without exact dimensions looks like it's at least 60 feet back from the road. So had the house been constructed where the carport is, I think that would have met the front setback. And I'm not trying to change anything. I'm just trying to say that 60 feet back from the road, I don't think is a tremendous hardship. I also had noticed that it's over 8.5 feet from the side property line. I know that infringes on the 15-foot setback, but a lot of cases we have zoning that require only a 7.5-foot setback, and it's greater than that. I'm not comparing apples to apples. I get that, but I think the resolution of denying the application may outweigh the benefit of actually approving it. That's my position.
Ma'am?
And I concur as well. I do believe because she no longer has the RV as well, and because of the homeowner value of the residents and stuff, and I definitely agree. I just think that it's an eyesore and it should be removed.
Okay. Now I get my opinion. As I've stated previously, I always have issues when something is built without permits, but in this case, she did consult a contractor told her he could build it. She relied on that. I will tell you the same thing I do every property owner is your responsibility to double check and make sure that what the contractor is telling you is true. Unfortunately, there are a lot of contractors that'll tell you whatever they want to tell you to be able to get your money and run. And it happens all the time. And that's the reason I asked if you were back in contact with him. I was curious to know if that contractor was still around, if you were able to contact them and resolve your issue through that contractor, because then it would be at their expense and not yours if we denied this. On the other hand, this structure has been there since 2019, am I correct? Okay. Since 2019, there was not a problem. The same property owner that is beside them was beside them when the building was built. They didn't have a problem when it was being built. Either they didn't notice it or at that point didn't care. And now that they're wanting to do something different with their property, all of a sudden it has become an issue to them. I think if it was a different property owner next to you, I would feel differently about this. But since it's property owner that's owned that property for some time, they've had plenty of time to deal with that issue. And it's only come to light when they removed the shrubbery and trees on their property, and they're wanting to do something different with their property. Now all of a sudden it's an issue for them. And I don't know that we should look at you and say that you've got to tear yours down just because he's decided he wants to do something else with his structure. I also don't necessarily believe that it is going to be injurious to property values. Real estate's what I do. And though it should be in line with your house, the fact that it's sitting so far back from the road, we've dealt with this on many, many occasions where we've allowed it in situations where it's been set that far back. The house was built further back, probably than it should have been built. But they wanted to set back toward the back, so they weren't close to the road. And then all of a sudden, when they needed to build another structure, they had problems because there were drain fields and there were septic tanks and there were wells, and they weren't able then to build behind the structure like, somebody else might be able to do. And so for those reasons, I would not support the motion to deny the variance. That's my statement. Okay. Anybody else have any comments? Feel free to take me to task. That's okay. None? I want to go through our 6 points. Special conditions and circumstances exist which are not applicable to the land, structures, or buildings in the same applicable zoning classification. Did you build the house? Okay. In this case, the house was in existence before the property owner that built the barn built it because of, and I'm taking totally her word for this, okay? Everybody understand that? Because that of the drain fields, et cetera, this was the only place that she could put that structure. In my opinion, that would be special conditions and circumstances which would allow her to put it in that place and would require the approval of a variance. Special conditions and circumstances do not result of the actions of the applicant. Again, they did not build the structure, they did not build the house. Therefore, they did not create those circumstances which required the structure to be built forward of the built property line or building line. Granting of the variance requested will not confer on the applicant any special privilege as denied by provisions of this chapter that the lands, buildings, or structures in the identical zoning classification. Again, we do not look at anyone and give them any special privileges regardless of their status or who they are. In this case, we've never met, so we would not be conferring any special privileges or upon her. Little enforcement of the provision of this chapter will deprive the applicant of rights commonly enjoyed by other properties in identical zoning classification of the provision of this chapter and will constitute an unnecessary and undue hardship on the applicant. If we said no to this, I don't think it deprives her of anything that would be enjoyed by other applicants, other than the fact she would not be able to have an RV structure to put her RV into, which somebody else might have. The only undue hardship in this case, since they no longer have the RV, would be the fact that she would have to tear down the structure that exists. And my opinion is I don't see that is necessary. But again, that's my opinion. That the variance granted is the minimum variance that will make possible the reasonable use of the land, building, or structure. In this case, it is the minimum variance that would be required for her to retain that structure. That the granting of the variance will be in harmony with the general intent and purpose of this chapter, and that such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. First, it is not detrimental to public welfare. Secondly, I think it does stay in line with general intent and purpose of this chapter in the fact that we have approved such things previously. As far as being injurious to the area involved, that is very subjective. In my opinion, it doesn't reduce property values. Somebody else's opinion, it might reduce property values. So I'm going to leave it as that is subjective, and I can't give a reasonable response to that. Is that fair, sir?
So just for the sake of discussion, because I want to go through that first point that you said.
Yes,
You said that it was, which, could you just repeat that for me? Right
absolutely.
quick?
That special conditions and circumstances exist which are not applicable to other land, structures, or buildings in the applicable zoning classification. And my statement was that she did not build the house, and due to the location of the house, and according to her, the drain fields and so forth behind there, it would prohibit them from building that structure further back.
Right. And so what I'm, and again, I mean, I started off this motion with a, I can see both sides of it, right? One, there is a concrete pad over where she parked, I assume, her everyday vehicles over there. So she would have been able to have a possible proper location for general.
It still would have been forward of the building line.
And it's still, okay. And then secondly, though, it was also done without permit. And so that's the one where I try to wrap my head around on the, if it was done properly, would this have been allowed? She still would have had to come before this board, correct?
She would have.
Yeah.
If she would have been given a permit in the beginning, it would have been subjective to her getting a variance.
Right.
And they would have had to come before us, get approval for the variance in order to build it there. In this case, and please correct me if I'm wrong, I can look back real quick, but I believe there's two variances. One is to the side setback, and the other is because it's forward of the principal structure.
Yes, that's correct.
Correct. In that case, if she would have come before us, and we could have said, hey, move it over, you don't need the side setback.
Right.
But we'd still had to give her permission to put it in front of her principal structure.
Got it. Okay. And you find that despite them not going through the proper process, that we would still, in your opinion, you've been doing this a lot longer than me, that you would have allowed for the variance despite no correct, not going through the process correctly, I guess, because that's really my big hangup right now, which leads to the other points, and that's where I very much struggle approving it, because I know that, in general, I mean, and I don't know that things have been approved prior to my time and others.
I think this entire board knows, anybody that's been around me knows, I get very uptight when somebody's built something without permit.
Mm-hmm.
In this case, when it's done the way that this was done, she says she talked to a contractor. The contractor said she could build it, and there have been situations where we've had them remove the buildings. There's been some where we've left it. The issue that we have is, do we believe her that she talked to a contractor and the contractor told her, yep, okay,
Right.
you're fine, go ahead, and she believed that contractor. Again, it is on her to double check and make sure that he's telling her the truth. But then ultimately, we make the decision as to, do we believe her that she honestly believed that it was okay to do that? At that point, then we go, is it reasonable to believe that you could build a structure of this nature without a permit? And a normal person would go, yeah, it's okay. In some cases that we've had, it wasn't reasonable to believe that. In some it is. And so that's to each person to determine in their mind if it's believable that they sincerely believe that they had the right to build this without permit, and that they weren't in violation of anything. Here's the thing. In the day and time that we're in, computers are easily accessible. And it doesn't take very long to jump online and find out what codes are.
Right.
And to find out if you can do it or can't do it. I guess my big deal with this one is it's been there for 4 years and it's not been a problem.
Okay.
And because of that, I am in favor of her keeping it. If it was something that was just built and the neighbor came to us and goes, hey, she built this thing and wasn't supposed to, that's a whole different animal. And I would be in favor of it being removed and her having to do something else. But because it's been there for 4 years and now all of a sudden it's an issue,
Right.
that's what my,
Okay. And then your second point was, because my favorite part about this board is we all have different backgrounds and experiences.
Yes,
That's kind of the point of it. You talked about your real estate background. Now, I appreciate her argument that the property value had gone up, but, I mean, my property value went up
everybody's-
$100,000 just because it was sitting there
Just
for 4
because you're in Florida, yeah.
Yeah, but if, in your opinion on this particular structure, can you give me your industry opinion on how it benefits rather than hurts the integrity of the neighborhood?
I don't know that it benefits.
Oh, okay, got it.
Okay. Do I think that it hurts? I don't. Again, if this was a quarter-acre lot, okay, I think that's a total different picture than what we're looking at here. This is a very large parcel. It's sitting way back off the road. You know, if it were over 6 feet further, then the only thing we're dealing with is the front building line. Okay? Does it become a problem that she builds this garage directly in front of her house? Or garage or carport directly in front of her house?
Sure.
Does it hamper property values? At that point, it would hamper hers.
Okay.
Okay? But where it's located, I don't think it's going to hamper hers. I legitimately don't think it's going to be an issue for a neighbor next door. But anytime you're dealing with real estate, it's always subjective to the person that's buying the property.
Sure.
One person will come in, it's no problem at all, it doesn't affect them. The next person it does. And example to that is high power lines run through people's backyards. Some folks will never buy a lot or never buy a house that those high power lines are going through. But yet there's houses built down through that people live in. To them, it doesn't bother them. So that's totally subjective. I'm not an appraiser.
Sure, yeah.
I can do CMAs.
Sure.
Is it something, if I was doing a CMA, that I would take value off of the house for in the CMA? The answer to that would be no.
Okay. And in his particular case, and I don't know if he's dividing the lot north, south, east, west into 2 potential buildings that he's building. That being said, I'm going to just, for the sake of discussion, just say it's 1 building. If their backyard is looking at that particular structure, in your mind as a real estate agent, does that harm his value for that 1 property?
I don't know if it's going to be a backyard or a side yard. If it's a backyard, it might,
Okay.
okay? If it's a side yard, probably not. But it all depends on how he builds the structure,
Okay.
okay? I certainly, when I'm looking at houses that I want to buy, I look at what's next to me. But I'm looking to see if it's in repair or disrepair, if it's falling down or not falling down, if there's junk all over the place or not.
Sure.
Those are the things I'm looking at.
Sure.
Somebody that's got a 2-story house next to me,
Okay.
it's a 2-story house.
Right.
Okay, it doesn't bother me.
Okay.
In my opinion, it doesn't affect. Again, I don't think it would affect the property values, but it might affect somebody's opinion.
Sure. Right. Okay. Okay. Yeah. That's why it's a tough one.
Mr. Chair.
Sir?
I appreciate the discussion on it because it's obviously we all feel for Ms. Marshall's predicament. If this property did not affect anybody else and it was just her that had the mistake was made and she was the only one that was being affected or penalized by it, then I could see approving this or approving the variance. But it also isn't Mr. Dalton's fault that the mistake was made by Mrs. Marshall's contractor, and whether that complaint was 4 days old or 4 years old, it doesn't make it any more correct. And so
That is true.
for him to be penalized by her contractor's mistake or potentially penalized, even because we could debate, as you said, the value may be affected, it may not be. But for argument's sake, I would lean towards the person who's going to be most affected, and that would be him. So I just wanted to share those thoughts after hearing your all's discussion.
Anything you want to interject?
No.
Ma'am? No. Anything further, sir?
Nope.
We have a motion and a second to deny the variance.
Both variances.
Both variances, excuse me, to deny both variances. All in favor of denying both variances, say aye.
Aye.
Opposed, say no. No. And a 3-2 vote, her variances are denied. I'm sorry. My suggestion to you is contract that contractor. That's all I can tell you. Mr. Bodie, may we have the next applicant requesting a variance?
Yes, item number 4, Cummings Family Revocable Trust requests variances at Chapter 62, Article 6, Brevard County Code as follows. Variance number 1, Section 62-1543, 5A, to permit a variance of 23.1 feet from the required 40-foot front setback for a structure. Variance number 2, Section 62-1443, 5B, to permit a variance of 13.81 feet from the required 15-foot side west setback for a structure. Variance number 3, Section 62-1443, 5C, to permit a variance of 20.12 feet from the required 25-foot rear setback for a structure in an AU light industrial zoning classification. This is located at tax account number 2421588 in District 2.
Please state your name and address for the record.
Hello?
There we go. Thank you.
My name is Jennifer Aldreche, and my address is 508 North Harbor City Boulevard, Melbourne, Florida, 32935.
Please raise your right hand. Do you swear or affirm the evidence you're about to give this Board of Adjustments is the truth?
Yes.
All right. And how may we help you?
We're here today on the 3 variances for this property. The property is under the Cummins Family Revocable Trust. This building was built in 1964. That was before my client transferred it over into the trust name. Right now, we are just solely trying to legitimize what is already there. We're not adding and we're not taking away. So right now, we're just asking for a variance for the actual building that's there. Nothing is going to be constructed over that. I think maybe the property that sits on the left side, at some point, there might have been a full connection, at some point, sold off during the history of the property, but now it's not in compliance. There isn't any code enforcement or anything like that against the property, but we do want to legitimize it.
Mr. McCann.
You were here in front of the board recently, weren't you?
Yes.
Was it for an adjacent property?
It was nearby. Yeah, there's one nearby. Yep.
Okay.
It was for some warehouses.
Was it for the same owners?
No, it's a different owner.
Okay. I've been by that location, and I just agree with you. The building's been pre-existing for a long period of time. It just, it is in a configuration that doesn't comply with the current setbacks, and I don't have any other questions. Thanks.
Thank you.
Sir? Sir? Ma'am? Sir? All right, stand to the side. I think this should be easy since there's nobody sitting out there. Is there anyone here that'd like to speak in favor or opposition to this variance request? Anybody want to jump out of the rafter? No, okay. Yeah, please come on back. Any final comment?
No.
Okay, you may be seated. What's your pleasure?
I'll make a motion to approve all 3 variance requests as depicted in the survey.
Second.
We have a motion by Mr. McCann to approve all 3 variance requests as depicted on survey. We have a second by Mr. Newman. Any discussion in this one? All right. 6 points. Special conditions, circumstances exist which are not applicable to other land structures or buildings. The applicable zoning classification, the special conditions, circumstances that exist are the fact the building was built prior to the owner purchasing the property. And that special conditions, circumstances then do not result from the actions of the applicant in the fact that he did not build those, so he did not create the situation. That granting the variance will not confer on the applicant any special privilege as denied by the provisions of this chapter of the lands, buildings, or structures in the identical zoning classification. And again, we are not conferring any special privileges. The literal enforcement of this provision in chapter would deprive the applicant of the rights commonly enjoyed by other properties in identical zoning classification under provisions of this chapter and constitute an unnecessary and undue hardship on the applicant. It would certainly be an unnecessary and undue hardship to have him remove all the structures that were pre-existing at the time that he purchased the property. That the variance granted is minimum variance that will make possible the reasonable use of land, building, or structure In this case, it is the minimum variance required to legitimize the structures that already exist. Granting of the variance will be in harmony with general intent and purposes of this chapter. Such variance will not be injurious to the area involved or otherwise detrimental to the public welfare. And I do not see this variance as being an issue, as being injurious to anyone at this point. We have a motion and a second. Any further discussion before I call for vote? Then I'm calling for a vote. All in favor of approving the variance, say aye. Aye. Any opposed? And your variance is approved. Just to note, so that everyone is aware, I will be absent at the next meeting in June. And so make sure you're here. We'll need you all here. At this time, there are no other cases before us. We stand adjourned.
Mr. Chair, before I let you guys go, I had emailed you last month the PowerPoint that we do for the new members. Just want to make sure that you all got it. If you have any questions, you can contact me after or what have you.
Is there anyone on the board that feels like and would need to go through that PowerPoint in a meeting? If so, we'd be happy to do it.
I'd be happy to do it. I don't know if we just have just a one-on-one with that, or if you want all of us to do it. I don't know what you did in the past, but I'd get benefit out of it.
Okay. Sonia?
You mean to meet and do it together?
Uh-huh.
Oh, we can meet and do it together if you want to do that. But I definitely got the PowerPoint.
Yeah, so if the board wanted to take up meeting time, we can do that, or if you want to contact me directly, that way if you don't want to hear that PowerPoint presentation again, that's certainly up to you. I'm just offering my services to you and being more educated.
So why don't we leave it at this point, if it's okay with you, Mr. Ball? If someone desires to meet with Mr. Ball and go through that PowerPoint, then we could do that. If there seems to be more than one, then maybe a meeting could be set to do it together rather than him having to do it multiple times.
Okay.
Would that be okay?
I serve at the pleasure of the board, so, whatever you guys.
And we certainly appreciate that. I remember when we first did it, it was extremely necessary, and it really benefited everyone because most everybody at that time was new to the process. And so it really changed the way the board operated because they began to understand things. So if you feel like, it's something that you need, I certainly encourage you to take advantage of that. If you go through the PowerPoint and you're not understanding it and you're not comprehending what is there and you feel like you need that training, then please take advantage of that. And if we need to do it as a board, I'd be happy to do it. Okay?
For clarification's point, if more than one individual needs it, I would recommend that it be during a regularly scheduled board meeting to avoid any sunshine law violations or appearance thereof.
Right. And I don't know if we would do it the same way we did it last time, is at the end of our meeting, then we adjourned and went to a different room and did it at that point. But however you would want to do that.
I think the first question is there a need to have it for more than one board member?
There's two of us. Yeah.
Okay, so what we can do is we can go through that PowerPoint presentation. And I would just this is just me thinking, we can do that after the meeting.
Okay.
I
That's
would recommend
probably-
at the end of a regularly scheduled
Yes,
meeting.
Okay.
after the regular meeting.
Okay, for June?
Well, I can't do June.
You can't do June?
No.
Okay, so we put it to July?
Darn, because I'm going to be gone.
We need Bill to be here for June.
We can schedule for July.
Why don't you just put it on the calendar and it would be responsible for everybody that is interested to make sure that they're here.
Right, so It doesn't,
And it doesn't take long to do.
Yeah, no, I mean, we can go through the slides probably 10, 15 minutes. It's the after discussion. We can do it for June if you want.
Well, he's not going to be here in June.
No, I get that, but he can, if he has any questions, he can call me and we can go over any questions that he has.
Do you want to just put it on the July agenda?
That's totally up to you. The PowerPoint's already done, so I don't have to take any time to do it.
Board, what do you want to do?
We could do it for
Are
July.
you
I'm
gone
fine
in
with
June?
that.
Is that the deal? or-
Yeah, I'm
Okay.
visiting. I got a new nephew.
And
I
since
got
he's
visit.
one of the ones wanting to see it.
Sure,
Let's put it on the July agenda,
that's good.
and hopefully we don't have a lot of cases that day.
Yeah.
Can we leave that subject to change? If we end up with like 8 or 10 cases, then
Sure,
we'll
we
move it to
can, we
another
can do
month.
that. When we, have we started the applications for July? No.
No,
So
not yet.
So let us take a look at when the deadline closes for July. If there's a light load like 4 or 5, we'll put it on the agenda. If it's more like 8, then we'll postpone it to the next meeting.
I just don't want everybody to have to stay until 5:30 in the evening to get it done. And you
We've
guys
done that
don't want
once
to.
already. We don't want to do it again.
Yes, we have. Yes, we have. All right. Guys, thanks for being here. We are adjourned.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.